When I started practicing law in 1982, there was no email. Clients are often surprised to find out that the chances of getting through an entire trademark opposition or cancellation proceeding that's contested all the way through is going to be well into six figures. There are a lot of people that are trying to scam users into providing personal information. And once you log in using your credentials for the real provider, then the bad actors suddenly have your login credentials. The AI has gotten stronger. So the savings to the client from being able to use this AI tool was substantial. It was close to $100,000 because AI in the hands of somebody with critical thinking skills is a valuable tool. In the hands of somebody without those tools, it's dangerous because it makes mistakes.
This is the Litigator's Edge, the podcast where smart strategy, practical innovation, and real-world experience come together to move litigation forward. Each week, we sit down with attorneys, legal tech leaders, and trusted advisors who are rethinking how great legal work gets done. You'll hear how law firms are building a competitive advantage. These conversations are grounded, insightful, and designed to help you refine how you work and how you win. Here is your host, Aniket Sawant.
Hello, and welcome to today's episode of The Litigator's Edge, the podcast where innovative attorneys reveal the strategies that have transformed their legal practice. My name is Aniket Sawant, and I'm co-founder and CEO of Threadio. My guest today is a high-level strategist and legal innovator who serves as the chair of the brand management practice group at FisherBroyles. With a career that spans from serving as worldwide trademark counsel for Digital Equipment Corporation to partnerships at some of the nation's most prestigious firms, he brings a rare client-side DNA to his practice. He's a recognized authority on global portfolio strategy, and he does it all while championing a tech-forward distributed firm model that prioritizes efficiency over overhead. It's my pleasure to welcome Larry Robbins to the podcast. Welcome, Larry, and thank you for being here.
Thank you very much for having me. I'm looking forward to this.
Absolutely. Likewise, Larry. As you know, I love to start by asking each of my guests either a fun fact about themselves or a cringe joke. Which will it be for you and what is it?
I have what my wife tells me is the cringiest joke ever.
Please, I'd love to hear it.
It's very simple. It goes like this. Why can't Helen Keller have children?
Why? I actually don't know the answer. That's a new one. I do not know.
Oh, well, that's good. Then this will be educational for you. The reason that Helen Keller can't have children is because she's dead.
Yes, when taken literally, that is true. Oh man, that was a good one. That's a new one.
Cringy enough for you?
Yes, that's that. Yeah, your wife is absolutely right. So
yeah. He usually is, but I'm not going to let her see this podcast after I admit that.
Sounds good. Larry, I do appreciate your making the time to be on the show. And I do believe that every attorney who does make the time to be on this podcast is a superhero. And every superhero has an origin story. And I know yours is a fascinating one. So would you mind please sharing it with our audience?
My origin story begins in 8th grade at Flossmoor Junior High School in Flossmoor, Illinois. Late in the year, we had to pick classes for freshman year high school the next year. And most of the classes, of course, were dictated, but we were allowed one elective. And I couldn't decide whether I wanted to take drama or debate. And I think we know which one out because you've never seen me on the silver screen.
Never too late to start.
I did choose debate. I ended up being a high school state champion debater, debated in college, and did moot court competition in law school. And that kind of kicked off an inexorable pathway to becoming an attorney as opposed to an actor.
That's wonderful. So how did you take that moment in 8th grade where you decided to go down the path of debate versus drama? What was your trajectory like after that? So high school, college, law school, all of that.
Okay, so as I mentioned, I was a debater in high school and college. That pretty much dominated my time in both. And in law school, I started law school in 1979. And for those of you who go back that far, you know that somebody with my background, which was a political science degree, didn't find their way to IP law very often, if at all. But I did find my way onto the Giles Sutherland Rich Moot Court competition team at Loyola Law School in Chicago. And we ended up coming in second place in the country in that competition. So the coach of the team, who is also the managing partner of us IP boutique in Chicago, hired both my partner and I. She had a technical background, so she was able to work as a patent lawyer. I did not, but I had all this great debate and moot court experience, so they figured we'll just make a litigator out of you. And that's how I ended up in IP law. Once I was there, I resisted several attempts to get me to do whatever was necessary to get licensed to be a patent attorney. Never had any interest in it. Still don't to this day. Love passing that work off to my partners. So I ended up in that firm working as a litigator, and I was there for about 11 years. And before I left, I was an equity partner. Left in end of 1993. Relocated the family to Massachusetts and became the worldwide trademark copyright counsel at Digital Equipment Corporation, or some might remember it as DEC.
That's great. Yeah. When I was looking up your profile, Larry, it was like DEC and Equipment Corporation was a name I hadn't heard for many years, and so it was really nice to see that your work there. What was that like, moving from being on the outside counsel side to in-house at a prominent technology company?
Not to mention completely geographically locating to some place where we knew nobody except my sister and brother-in-law. It was a shock for all of us, except for maybe my younger son, who was only 3 at the time. It probably didn't have a tremendous effect on him. So as I mentioned, I was 90% of my time in Chicago was litigating trademark and copyright cases, and occasionally even a little bit of patent litigation. When I got to DEC Digital, my job was to manage a global trademark portfolio that was massive. And I had, at the time I joined, 5 paralegals on staff to help with that, which should give you some sense of how large the portfolio was. It had recently increased substantially because the company had made a branding decision to stop using the DEC name and to use digital as the global brand identity. So there were years and years and years of accumulated registrations and filing for the DEC mark and marks using the DEC formative as part of compound marks. We were responsible for managing that portfolio, managing outside counsel enforcement uh, in in pretty much the entire world. That was far and away before since the most uh, broad geographic trademark portfolio I've ever worked with and am likely to ever work with again. It required an attention to a completely different kind of detail than I was used to in litigation. In litigation, obviously, you're focused on the fact patterns, the documents, the case law for the particular case that you're working on. That can get big. I mean, it can get expansive, but it's not the degree of you detail involved in a several thousand mark trademark portfolio, which is why there were so many paralegals that helped, because each one was responsible for a particular portfolio of marks, and they would do the grunt works, so to speak, on those. And we would meet pretty much every day. I'd meet with each of them and we'd go over what the issues were in these particular regions. But it was very interesting at the time that I was there, the company hired a new chief marketing officer, and he had a gentleman who essentially was, I would call him the brand policeman, for lack of a better word. And his job was to end the company practice of developing trademarks for every little product, every little feature of a product, and trying to register those trademarks for every product and every feature of a product. So we had to work together, and this took quite some time to figure out, what marks were important, what marks we could let go, and what process are we going to put in place that's going to slow this avalanche of trademark clearance and requests. So we came up with a branding rubric that said if it's a major product and the digital brand was not enough to represent it and you needed a specific brand name, that was fine. If it was a minor product, then you're just going to have to get along with the generic term for that, unless you can make a very persuasive case as to why even that feature or that subproduct had to have a different name. Nobody ever made that case, not surprisingly. The result was that we were able to reduce the number of new filings and the size of that portfolio substantially over the 2-3 years that I was there. But it was also a really good learning point for me because it really taught me how to look at a trademark portfolio, figure out what really mattered, what really doesn't matter, have the power or the willingness, for lack of a better word, to cut where cutting was necessary. Say, these are not necessary. Yes, we own them. Yes, they probably have some residual value to, but they do not have value to the company. They do not have value to the bottom line. And there's no market for them to sell them to third parties, nor would we want to, since they're still very much associated with our business. And that has informed the way I practice trademark portfolio development ever since. And it's given me rubrics for advising clients on how to prioritize geographies, how to prioritize marks, how to prioritize levels of branding, everything that I basically just discussed.
That's great. A few things that jumped out from what you just shared there, Larry. So one is that when you first made the move to digital, and I personally, I was much younger than I am now. I remember the lowercase DIGITAL sort of in the maroon background. I think that was one of the marks that at least I remember. Is it fair to say then that the sheer size of the portfolio that existed at the time that you came in, was that because of the lack of a rubric that yourself and the brand policeman had sort of enforced, like that did not exist before, and so you had this burgeoning sort of portfolio? Was that the reason, or were there other reasons why the portfolio was so huge?
I think that was primarily the reason. I wasn't there, so it's hard to talk
Right.
to. I mean, obviously, I had some institutional memory from my paralegal staff,
Right.
but they weren't the people making the decisions. They were just the people implementing them.
Right.
But I think it was just nobody really looked at the trademark portfolio as a cost center as opposed to a asset. And when we decided to change that focus to, hey, these are valuable intellectual property assets, but some of these have no value at all whatsoever. So we need to separate the wheat from the chaff and focus on what's important to the company, what's driving revenue, and what is actually enforceable and valuable to the company going forward.
Makes a lot of sense. Um, can you share maybe one or two examples of how you did sort of actualize the fact that all of this brand portfolio was an asset? Can you share one or two examples to the extent that you can?
Well, the most important decision, which I alluded to earlier, was to just abandon the entire portfolio of deck formative marks. The decision had been made that the company was going to be digital from that point forward in the maroon squares, as you mentioned, as opposed to the blue squares, which had preceded those. So that was half, if not more, than the portfolio. We just pitched it. That's it. We're not going to use it. And the fact of the matter is, the company was sold within 3 years, and the whole name disappeared completely. So that was definitely the right decision. Um, and then I think the other place where we saved a lot of resources was implementing that system with the brand manager gatekeeper, who they had to make a case to him that a trademark was necessary, and you couldn't just go with digital PC or digital router. Why did it have to be a digital XYZ PC or router? And like I said, very rarely could they make their case. They did make the case with a line of laptops and PCs, picked a bunch of horrible names and never won anywhere, but
That's great.
But that was ditching the duck and putting a gatekeeper on what came down the pipe for new is what brought that under control. And I think we probably shaved at least $1 million, if not more, off of the trademark budget by doing that.
And this is decades ago, so that's actually worth a lot more in today's money. So that's incredible.
Yeah, all the way back in the early 90s.
Amazing.
See, that's why I told you before we started recording, I had to use AI to research my own career. So some of those things from back in those days are a little cloudy. 30 years later.
That's great. Thank you for sharing your description of your time at digital. Let's talk about your trajectory after that. So what happens? After digital, what has your trajectory been like?
It was pretty apparent to all of us that the company was going to be sold. It was also apparent to me that as somebody who had only been there for a little over 2 years, that my severance, which at the time would have been 6 weeks, was going to be problematic. So I started to proactively look for a jumping off point, and fortunately found one with a very highly regarded tech firm in Boston that had a fairly newly formed licensing department within the corporate group, and thought that my expertise in trademark and copyright law might enhance the licensing advice they were able to give to the corporate partners. It worked out a little bit differently, as we'll get into shortly, but that was the thinking. They didn't require any portable business, which was key since I had given up all of my business when I had moved from Chicago to Maynard, Massachusetts to work at Tech Digital, whatever.
That makes sense.
So I arrived at that firm and very quickly discovered that the bulk of my job was going to be software licensing, which was something I had absolutely zero experience with prior to the day I walked into the door at that firm. But I learned it as best as I could. Worked there for a couple of years, but that was not really my ideal where I saw my career going. And so after 2 years, I looked to get out and go to another firm where I could go back to practicing primarily trademark, copyright law, litigation, et cetera. And that's what I've been doing ever since.
That's great, Larry. How has the nature of trademark or copyright litigation changed over the 3 decades or so since you came out of digital? And what can you share about that?
I'm going to go back a little further than your question and go back to when I was in Chicago, because I wasn't doing litigation. I was managing some when I was at digital. The technology is probably the biggest difference. When I started practicing law in 1982, our technology was weighing word processors. Our fax machines were those little tubes that the paper circled in at rapid high speed and somehow got sent somewhere else, came out on this horrible kind of paper that rubbed off on everything. There was no email. Everything, we used messenger services a lot, used the telephone a lot. I spent very long hours typing out and writing things out longhand. And to a certain degree, I think that because of that, litigation was probably a bit simpler then. The quantity of documents involved and the nature of work was different. I almost forgot the most important thing. We did legal research with books and Shepherds. We didn't have Lexis or Westlaw when I started out, and those didn't really become popular until I was already a partner, and other people, we had associates who would do legal research for me at that time. So I had to learn Lexis, Westlaw a lot later in life than a lot of other people did, and that was fun. So I think, and over time now, because we have electronic discovery, which obviously wasn't a thing back then, the amount of information, documentation, et cetera, is, I don't even think exponentially is a big enough word to describe how much more complicated litigation is. And it's a pretty significant factor in why I don't do litigation, first tier litigation anymore, other than TTAB cases. That's for other people now at this point in my career.
Makes sense.
But that's it. But also, I mean, AI recently, in terms of drafting pleadings, helping with research and the like, No one imagined that uh, when I was at Digital or before. And when I was and I saw some pretty amazing things when I was at Digital. I saw wireless telephone communication before it existed. I saw digital currency before it existed, and probably several other things that I just don't remember. But Digital was not a particularly good marketing company, but as a technology company goes, I can't imagine there were many better before or since. And it was just remarkable to see the ideas that were coming out, uh, and how eventually, long after the company was gone, those ideas hit commercially. But one thing they did not see at that time was AI.
Yeah, no, yeah, we'll come to AI and sort of how you use it in your practice in just a little bit. So I do want to go back to one thing that you mentioned, which is that right now the primary focus of whatever litigation you do is TTAB. What what fraction of your time do you spend on that type of litigation, and what should those who are maybe not as familiar with TTAB litigation be aware of, or what would you like people to know about how that's different from, say, traditional litigation?
The answer to your first question is it varies. Currently, the amount of time I spend on TTAB litigation is zero because I don't have an active case right now. Um, it can get as high as 20, 30%, but most of my time is strategic trademark portfolio development advice and online enforcement. I do far more UDRP work than trademark trial appeal board work, which we'll also get into in a bit.
Yep, absolutely. Yeah, so on the TTAB side, can you maybe sort of share what that looks like? How is that different from, like traditional courtroom based litigation?
It's the major difference is that it pretty much all takes place outside of a courtroom. Not even pretty much, other than the oral hearing at the very end, which is optional depending on whether the parties or not. Everything is done remotely. Papers, exhibits, evidence are all filed with the trademark office. The trial is held on paper by submission of briefs and by what's called a notice of reliance, which is how you submit your evidence. The discovery process is the same as it would be in litigation. We document requests for admission, interrogatories, depositions, etc. Discovery motion practice is the same, absent oral hearings. Everything's done on paper. Uh, so it's very much like litigation without the court appearances. There's no damages in trademark office cases, so there's no discovery or expert witness or all the other accoutrements to building a damages case in the litigation context. But other than that, it looks very much like litigation. And as a result, while it's not as expensive as district court litigation, it's not inexpensive either. And clients are often surprised to find out that the chances of getting through an entire trademark opposition or cancellation proceeding that's contested all the way through what's called trial and oral argument and decision is going to be well into six figures, but is very unlikely, except in the most contested cases, that it's ever going to get all that close to seven figures.
Makes sense. Thank you for sharing that, Larry. Moving to the non-litigation part of your day-to-day, or the work that you do. And so as I was doing some research on your profile, Larry, I came across the fact that you have a niche expertise in the furniture industry and dealing with design patents and trade dress, which I would assume are areas that are generally harder to protect. So for our listeners in industries where the appearance or the look is the product, what can you share, like a creative strategy that you've used or employed to essentially stop a knockoff, or otherwise take action when traditional methods fall short?
Sure. We have my wife to thank for that expertise. She's an interior designer, and in the interest of solidarity and support, I decided to focus on her industry a bit. And
That's great. Wow.
there's an interesting story here. When I was at Finnegan, one of the associates and I wrote a series of articles, trademark, copyright, design patent protection for furniture, and they were published in Furniture World magazine. I've written a lot of articles over the years, and most of them, except for those 3, were published in legal publications. I never got an inquiry or a piece of work from anything I ever published in a legal publication. But to this day, probably 17, 18 years later, I still get calls from people who find those articles online and contact me because they have some type of intellectual property um, issue with furniture. So for the listeners, the takeaway point there is you might be better off writing your legal articles for trade journals and other areas as opposed to getting published in publications read by other lawyers. Okay, but to answer your question, as you rightly point out, it's very hard to get IP protection for items like furniture because so much of it is functional. I've found that the most effective means of protecting the furniture design, at least right now, is via design patent, because design patents perception of what is original and I don't remember the exact patent words. Novel is a little more liberal right now than copyright. Copyright, if you don't have something that's pretty obviously ornamental that you could separate and present separately, it's a tough sell. But the design patents are a little bit better. From a trade dress perspective, obviously product design is not inherently distinctive from day one. So we have to work with clients and talk to them about things like, look for advertising. If you want to develop a trademark or trade dress protection in a particular aspect of a design, you need to start from the very beginning and you need to focus on the unique design aspect in your advertising and promotion and highlight them, point them out so that they become associated with you and your brand and your company and start to function similarly to a trademark as a brand identifier. Now that's in a perfect world. I don't work in a perfect world, and these situations generally arrive on my desk long after that type of program should have been implemented. In that case, it's sometimes very difficult because you look and say, well, maybe had you been, you know, emphasizing this in your advertising, your catalogs, your promotion early on, we'd have something to work with, but you don't have anything. So I have the furniture clients I do have. We focus on design protection, and we talk about how branding. Yeah, always an actual trademark. If you establish a product and the product becomes very popular, and there's demand for that product, and you have a good trademark associated with that product, then people are not just looking for I want that chair with the fancy rolling armrests with the cool little squiggles at the end. They want the Apex brand chair because you've built up your brand over that time. Somebody else comes out with a chair that looks the same. You say, well, that looks the same, but it's obviously not the Apex chair because the Apex brand isn't there. So I think between trademark and design patent, that's still the strongest combination of IP protection for furniture and even a lot of other product designs.
That's so fascinating. It's really nice to see a deep dive into an area that at least most attorneys and certainly the general public doesn't necessarily think about, except in the manner that you mentioned from seeing advertising and hey, that's an Apex share versus not. Moving to another area that you have a good amount of expertise and experience in, which is fantasy sports. And so you've represented fantasy sports providers and handled issues for sports entities. I would imagine that the dynamics of that industry are quite different than the furniture industry. And so what kind of work do you do there, and how does your strategy for supporting or guiding your clients change in this environment versus the previous?
I have been involved in that industry since almost the very beginning. I won't mention any names, but anybody who's interested could probably pretty easily figure out who my primary client is. It's all over the trademark office records. So, things have changed. That particular client was a startup when I started working on them. The first thing we had to do was secure the name. There was somebody else that had a football prediction sheet that used the same name. We wanted to make sure that that didn't become a problem down the road. So we took care of that from the very beginning. Over time, the company originally did fantasy sports. Over time, that grew into some more media as technology evolved from the 2012, 2013 into 2025. And, along the way, podcasting became a thing and they got into that. NFTs became a thing for a while. They got into that. Sports betting became legal in many states. That's been a massive change in the industry. What we did a lot at the beginning is try to negotiate the strain between a provider that was offering games with regard to sports and the sports leagues and the NCAA schools intellectual property. What could we use? What type of player likenesses? What kind of logos could we use? What couldn't we use? How could we promote events, promotions, and competitions based on popular events like the Masters, the Olympics, and things like that? How do you negotiate the strain between being able to identify what you're doing in relation to those events and the fact that the owners and operators of those events are notoriously aggressive in enforcing their trademark rights? So that's the kind of work that we did then. It has evolved as a lot of domain name squatting and a lot of there's a lot of money in that business. And so there are a lot of people that are trying to scam users into providing personal information, access to accounts and the like. And a lot of our domain name enforcement that we do for them is around sites that do just that. They mimic the actual site. They try to entice users to log in to the site, and once you log in using your credentials for the real provider, then the bad actors suddenly have your login credentials and they can go into your account and clean it up. This is a very serious problem. It's and one of the scams that I've seen for this particular client over the years that we've addressed. Got some other interesting ones too for some other clients if you're interested that have nothing to do with fantasy sports or sports betting. But
Yeah, no, I would love to hear. I think this is because this sits at the intersection of not just enforcement from an IP perspective, but also cybersecurity and implications for the public at large. So yeah, if you have another just high level anecdote, I think we would love to hear that.
sure, I had another client that in the medical tech area, and they had a problem with cyber squatters that were registering domains that were similar to their name and then contacting potential employers and making job offers. And they had all the paperwork, they had taken the company logos, made the applications, made everything look like it came from the company, had these people fill out all of their information, including their social security numbers and the like, tell them they were going to get a job, and then abscond with the personal information. There was no job. Of course, that made these people very angry at the company, and so they would contact, HR at the company and say, "Hey, what happened to my job offer?" And the company said, "Well, we've never heard of you."
Oh my gosh.
That's that we knocked out about 2 or 3 operators. Now, it's not just us. We took care of the domain names. We shut down the use of the trademark to do that. They obviously also worked with criminal law enforcement on the side to do that as well. It's not something that you can simply address through trademark law. They also had issues with the squatters using domain names similar to or identical to the company name to direct people to sites where they sold counterfeit equipment or unauthorized used equipment. So there are a lot of scams. That's for the fantasy sports company. In addition to the scam that I described, very commonly that people will set up a page that looks like my client's page, and when you start clicking on the links, they take you to a competitor's link. Usually, some obscure online casino site that nobody's ever heard of. They're not going to get any traffic unless they can somehow trick the users of the primary online casino brands to go over to their site instead. I can't speak for the other major providers. I suspect that the in-house and outside counsel for those companies deal with exactly the same type of scam activity.
Wow, thank you for sharing that, Larry. I imagine, and we'll talk about this in a minute, but I imagine that all of this is just going to be exacerbated with AI and deep fakes and all of that, I would imagine, right?
It's a lot easier to make something look legitimate with AI than it was before. Yeah, but on the other hand, AI makes it easier to find too. I I have a standing agent that goes out every Monday and looks for new new sites that use the client's name or a close derivative of the client's name and that are live, and they send me back the information. I can look at them and figure out whether or not we want to take any action or not. So it cuts both ways.
That that's great. That's a very tech forward, way of using AI to your advantage. And so, are there other while we're on the subject, what are some other ways that your firm and you use AI in your day to day work?
I have been relying pretty much exclusively on product I license for trademark search and watching. That is AI based. I started working with them about a year and a half ago, very tentatively. I was used to working with the legacy trademark searching firms, Core Search, Clarivate, and the like. I was used to getting those big, thick reports and having to go through them and figuring out what was available. This was a whole new concept. And the product was sold as being as good or better. So, of course, the first several times I used it, I ordered searches from my legacy provider, did searches with this company, compared the results, was happy every time that they found the same stuff or even a little bit more, and eventually transitioned completely away from using legacy providers. Over that time, this product has gotten better and better and better. There are more features. The AI has gotten stronger. Uh, and so I use that pretty much exclusively for search now. And I posted something on LinkedIn 2 or 3 weeks ago, which I think is really interesting. A client contacted me and wanted to know how many trademark searches we had done for them over the last year and what it cost. So I went through and found all of the entries for all the searches and figured out there was about 50 searches, 55 searches that we had done. And the total cost to the client for the review of those searches and the opinion came out to about 35, $40,000. So as mental exercises, well, what would this have cost if I never had the product I use now and instead had used the legacy trademark search providers, got the thick reports and went through those. And it was close to $100,000.
Wow.
So the savings to the client from being able to use this AI tool was substantial, and uh, that might be problematic for a lawyer in a firm where billable hours and the like are really important. But in our model, the ability to be able to provide clients that kind of service, at that kind of price works because I still make what I need to make. Yeah, I don't need those searches to cost $100,000 to be profitable. It's fine if they cost 50.
That's fantastic.
So to continue, so that's search. To continue to answer your question, this product also allows me to do watch, and it allows me to do watch from my desktop over 195 different countries. So I package together watch services for clients. Again, very reasonably priced in comparison to what I was paying to the legacy providers. I get much more useful results. I don't get the extraneous, we'll use crap, lack of a better word, that I got in watch reports. Mark said, so why are you even showing this to me? Nobody in their right mind would even think of this as a potential problem. But you had to wade through all of those. That doesn't happen here. The AI gets rid of all of the nonsense. I can see it if I want. I have that option, but it's much quicker. So again, we're able to offer watch services to clients for a fraction of what we charged when we had to use the legacy provider. The other thing that we are able to do with AI is competitive intelligence. We can keep an eye on competitors in a particular field, watch their trademark portfolio, look at what they're filing, get some intelligence on where they're going from a product perspective. Also, geographically, are they starting to file in a different part of the world? What are they going to be doing over there? That type of thing. We're able to do that very easily, again, very inexpensively. Um, that's just that product. And obviously AI for research alone, legal research, drafting, all my office actions. Now, if I get a trademark office action now, the first thing I do is I copy it, throw it into AI, say, give me an outline for a response. It's not that simple. I kind of tell it what I want in the response, what arguments I want to make, and then give it back to me. And of course, that takes 5 minutes. I mean, not 5 minutes, 5 seconds. Uh, and I get a product that is so much better than what I used to get from associates. It's been 8 years since I worked at a firm where I had associates to work with, but other than some rare, really, really good ones, I'm sure they know who they are if they're listening. Most of what I got was, you know, it was something to work with, and I've always been someone who works much better from a draft than coming up with it myself. I don't know if that's ADD or something like that, but in any event, AI is a godsend to me from that because it gives me something that's already really high quality, and I can work with that. I can tweak it. I can go back and forth with it over several iterations, saying I think you're wrong. This doesn't make any sense based on this, and it'll go back and come back, and it's like having a very high level discussion with a very smart person, probably smarter than me, and I end up with a work product that the success rate in responses that I filed in the trademark office since I've started using AI to enhance the responses is it's already pretty good, but now I'm almost infallible. Not quite, because nobody is, but I mean, we're able to win cases, the first time around, the first response that either were not winnable in the past or took second office actions or even requests for reconsideration before we could finally win them. That, of course, is another place that, not only gets the clients the results they want, but it saves, substantial money. I will still spend as much time as I used to spend on an office action response, but nobody else is spending that time. It's not like there's an associate spending 5 hours to give me what I started with. What I started with took 5 seconds. It got me to where those 5 hours were. And as a result, the cost to clients probably 40-50% less than it was prior to AI with better product and better results. Um, I think what AI does for legal practice is it really helps you with precision. Everything is much more focused and correct, and even more so velocity. You can do everything so much more quickly. And I me personally, I'm more engaged with something at the beginning, and the longer I have to work at it, the more drafts I have to go through, the more difficult it is, and at that point, I have to get someone else involved because you need to look at this and make sure I'm not missing anything. I get to that point more quickly. I still, in cases that warrant it, will have somebody take a second look, but it's not the same process. It does not. It unfolds over hours instead of days, and that's great for me. It has some implications for traditional law practice structure and some huge implications for young attorneys and attorneys coming out of law school, which I think we're gonna get to a bit later.
Absolutely. Yeah, there's so much there in what you shared, Larry. It's amazing. So I think it's pretty clear that both you personally as well as your law firm, you're using AI in many different and distinctive ways, and it also gives me the sense that your firm, at least the one you've been at for the last 8 years or so, is very innovative. It's distributed. Obviously, it has this very tech forward approach to things. Can you share a little bit more about your firm and how you operate? You mentioned you don't have so many associates. You use AI a lot, and the legal structure is different. So can you talk a little bit about that?
Yeah, I could talk about this all day, and I invite any listener who is intrigued by anything I say to feel free to contact me. Um, I was, working at another firm in Boston, and I got a call from a headhunter one day who described to me a law firm where you could work from home, you could work as much as you wanted, as many hours with no billable hour requirements. You could enter into any kind of relationship with your clients you wished, bill them at whatever rate you wanted to bill them, with a certain minimum, which was so low that it wasn't even a consideration. And you can keep 80% of what you bill and collect. And if you work on somebody else's client's work, you can keep 48% of what they bill and collect for the work that you did. And if you give work to somebody else in a field of law that you're not an expert, then you can keep 32%, or if you're more generous, which I tend to be, you can give what we call our minder credit, which is the person who's in charge of managing a particular product, half of that 32, 16%, and then keep what's called the finder credit for 16%. So I looked at that, I said, that's just too good to be true. So I called my accountant, went through it all. We tried to poke holes in it, and he and I came to the conclusion, "Yep, it's pretty good, pretty good." So I decided to move forward, submitted all my paperwork. The firm has a minimum requirement for portable business because this, as you can tell, is the ultimate eat what you kill situation. And if you walk into this firm and you inflate what business you have and then you don't perform to that level, there's only one person that gets hurt, and that's you. Um, but yeah, I did the interview, went great, got hired. I've been here for 8 years. It has been every bit of what I expected and more. I was able to lower my billing rate over $200 an hour from what I was billing at the Boston firm before I came here, and make more money. I was able to, and even today, my billing rate has gone up, you know, a reasonable amount over 8 years, but I don't think I'm up to what it was when I left that other firm 8 years ago yet. I could, but there's not really a need to, because the way we split revenue, you you can make plenty of money in a way that's very efficient for your clients. The other thing is, as I mentioned, I worked for a number of firms over the course of my career, all traditional law firm model firms. This firm, where none of us are in the same place, is far and away the most collaborative environment I have ever worked in the entire 44 years of my career outside of being in-house. And the reason for that is the compensation structure I described. We all do well working with each other, for each other, et cetera. And um, there's no negative incentive to hoard work and to keep credit, because there's no compensation committee that's going to look at that at the end of the year. You're getting your 80%, and we have a profit share also at the end of the year that works on certain percentages and the like. And that's it. It's about as straightforward as it could possibly be. Takes all the politics out of it. It's simply people trying to get the work done for their clients the best way they can by the best people to do the particular work that the client needs.
That's fantastic. It does sound like a very innovative approach to legal practice, and thank you for sharing all those details. Right.
And like we said, there's no overhead because we don't have offices. I mean, I could get an office if I wanted, but that I'd pay for that myself. I have a paralegal. I pay her myself. The firm pays her, provides benefits and the like as an employee, but then I'm charged for all.
So it's almost like you're your own business within the firm, if you will, with your own P&L in a way, right? Your own revenues and your own expenses and things like that.
That's exactly right. Except you have a central firm that's providing, accounting infrastructure, IT infrastructure, marketing, and then an entire, full spectrum, large law firm, national practice, stocked with partners who all came from AmLaw 200 firms or high-powered boutiques or the like. So the level of expertise here is outstanding. We can work together without associates because our billing rates are uniformly lower and mostly lower than associates at BinLaw. But you're getting me. You're not getting a third-year associate working on your work. So that works out great for clients. It works out great for us. We do get together. We have a retreat every year. We also have a couple what we call mini retreats that they move around the country to be convenient to one group or another where we can get together and meet in person, which I try to make as many of those as I can. Because there's still no substitute for FaceTime, even in a firm where there's no FaceTime. Or where FaceTime is all there is, but not literal FaceTime,
Right.
electronic FaceTime.
Absolutely. That's fantastic. Well, Larry, this has been a wonderful conversation. Just a couple of quick questions to round us out here. So throughout your 4+ decades, you've seen quite a few things, and you've experienced, and I've driven quite a few things. You've also spent some time as an educator, so you taught at a university for a little bit. You also alluded to the fact that, hey, early career or junior attorneys, may want to look out for certain things, especially with the rise of AI and so on and so forth. So for early career attorneys, maybe they're coming out of law school, or maybe they're fresh out of law school and working as a 1st to 5th year associate somewhere, what sort of guidance would you have for them as they look at the current societal, technological, economic, political, etc. landscape and are potentially thinking of building a career in IP law?
Okay, I'm going to preface this answer with the point that I made earlier. I have been at this firm for 8 years. We don't have associates. I have not worked with an associate in 8 years. That being said, today, at this point in time, I would say that if you are coming out of law school, you need to master 2 things. You need to master AI, using AI in legal workflows, working with it to use it as a tool, not as a substitute for your own work. Which leads to the second is that you have to have developed critical thinking skills that are above and beyond your peers. Because AI in the hands of somebody with critical thinking skills is a valuable tool. In the hands of somebody without those tools, it's dangerous because it makes mistakes, it reaches wrong conclusions. You have to be able to recognize those. And if you have not done the work to learn your area of law, even if you have to do that on your own time, because nobody's going to pay you to spend hours and hours doing legal research like they did 10, 15, 20 years ago, you got to put that time in because you need to be able to manage the tools that are going to be at the center of your practice moving forward. And that is going to require you to try as hard as you can to know more than the tool that you're working with. Now, I know that's impossible. You're never going to know more, but you have something that it doesn't, at least now, and that's judgment. But that judgment requires critical thinking ability and a deep well of knowledge so that you can assess the data that you're receiving in the context of a body of knowledge in the field of law and learned experience that only a human can bring to the table.
That's wonderful advice. Thank you for sharing that, Larry. Okay, final question for you. Is there a question that I should have asked you but I didn't?
Who's gonna win the NFC North?
Sure, please. Let's see if that turns out to be the case when we go live with this, or when we release this recording.
I'm gonna go on a limb right now and say that my Green Bay Packers are gonna win the North.
We shall see. Yeah. Well, good luck to the Packers and good luck to all the teams. But Larry, this has been a wonderful conversation. Thank you so much for your time, for your insights. I learned a lot, not just about your career and your trajectory, but also about many aspects of the law and technology and legal practice. So thank you so much for your time and your insights. And I really do appreciate it.
Well, thanks, Aniket. This has been really fun. Never did anything like this before. I think I'm hooked now.
That's great. Awesome. All right. Thank you so much, Larry.
You're welcome.
The Litigator's Edge podcast requires more than a conversation. It takes action, research, and collective wisdom. If today's episode resonated with you, we'd love to hear your insights. Join the conversation and help us shape the future together. We'll be back with more stories, strategies, and real-world solutions that are making a difference for everyone. In the meantime, be sure to subscribe, rate, write a review, and share it with someone you think would benefit from it too. Thanks for listening, and we'll see you on the next episode.